Hello everyone, this is Gilbert Jalad again on Tufts on Tax from CPLSPA headquarters, where all your tax questions are answered right here with Mr. T. Scott Tufts. If you have any questions or any concerns about your taxes, lawsuits you are in with either employers or employees or even with the IRS, if you have any questions or you want your questions answered, you can call T. Scott Tufts here, Tufts on Tax, at 877-647-7887. Again, that's 877-647-7887. And if you are watching our YouTube channel, our number will be on the screen in the bottom. And also, you can email him at stufts@cplspa.com. That's stufts@cplspa.com. Hello, Scott. How are you today?
Hey, good to be with you.
Good to be with you, too. Another episode and more taxes and more forms and more questions to answer about taxes.
Well, let's not let the forms bore you or concern you. Let's get after it.
Yes, absolutely. They are what they are, so we have to go through them anyway, right?
Unfortunate part of life, maybe.
Yeah, part of life that the government put us into.
Exactly.
Okay, so today we're going to be talking about IRS Form SS-8. So my first question would be here, what is IRS Form SS-8?
All right, so this, we at Tufts on Tax talk about these forms, Gilbert, that are the proverbial match in the forest idea that can create litigation or problems. So the SS-8 deals with independent contractor versus employee. And if you are a business or an employee or you believe you might be an employee, but you're being classified as an independent contractor, or you just don't know, the SS-8 is the form that you can actually fill in and submit all the documents that it walks through and have a part of the IRS make a determination as to your status.
So that brings me to this other question. Why does the IRS have this form?
Well, so you would look at it maybe this way. Determinations of whether someone is an independent contractor or an employee under our federal tax laws, for example, depend on a lot of factors, a lot of different criteria, different things that most people don't know. So the idea that there's a form that can walk someone through how the IRS approaches the issue and gives them a chance to take a look at it, gives the consumer, the taxpayer, the independent contractor or the person, the worker, or even a business, a chance to get that input from the IRS. So think of it almost like a consumer helpline or an assistance line, a hotline. But yet this form is very detailed, and that's what we want to talk about today.
Okay. I have another question here for you. What happens if the person or the company that is submitting the form, SS-8, to get a determination doesn't like the answer they get when they
so this is the idea that, when you think of getting audited or having IRS questions come up, nobody wants that, but if it does, there's all kinds of administrative law things that would kick in, meaning that you work with an agency, you get your dispute, you try and get it resolved without going to court. So when you deal with the IRS, you have that usual process. But this isn't that process. This is a kind of separate thing that sits there and allows you to get a determination, but there are no rights of appeal or approaches that you can take. In other words, this is a private determination that is made that can then leave for the IRS to refer it out to have it looked at, but it's not something that you can appeal.
Yeah, that was my next question. Can they appeal it? I guess they have to go to court.
Right. So you actually don't, the context of this SS-8 is that you submit it and you get this input from the IRS. And you have to abide by it privately with the potential employer or whatnot. This can create all kinds of problems because then what does the employer do? The employer does the employer go on offense and change the way they were doing things or push back on that? And then there's so many. One of the reasons why we want to get into this is that being an employee or independent contractor has features to it that are more than just tax, right? There could be protections given to employees that are not afforded to independent contractors.
I see.
Right? Federal laws that protect overtime, unemployment, right? You start to think through what the benefits are that are provided to employees that are not customarily provided to the independent contractor. So the SS-8 becomes a very important document that you might, many of our listeners may not have run into before.
Now, after you said they can't appeal, they can go to court. So what does the IRS do with this determination?
Yeah, so there's not a guarantee that they'll refer it to for review or to create an audit, let's say, based on a change. For example, let's say the determination you get is consistent with what the business has been doing. Well, there would be no ramification of that other than the person seeking that determination may not be happy with it or may not agree with it. So it's really the situation where the determination that is made is inconsistent with how it's been done, that it then creates an impact, right? Basically the both parties are notified. So if you're a worker, let's just kind of say you're a worker and you were to use this form and turn it in, and the IRS were to then take a look at it, right, and then make that determination, and it's contrary to the way that you are currently being treated, then those changes then impact you, right, and the business, right? At that point, what about other workers that are just like you? Will they be impacted? Okay, so this is kind of why I want folks to know about this form, and think about it. And we this is what we do, Gilbert. We're trying to say, boy, there are forms out there that are different than your normal forms that create litigation or find themselves in the middle of litigation.
No, I filed taxes and I did. I saw many forms, but I never looked at a SS-8. I never knew what SS-8 mean.
That's the thing. There's just so many forms. That's what we're trying to get the word out, that there are many forms folks don't know about. Now, everyone probably knows about a 1099.
Yeah.
Which is it used to be that independent contractors got a 1099 miscellaneous, MISC.
Correct.
But they've changed in the last 2 years. They have created, or brought back a form called a 1099 NEC, and that stands for non-employee compensation. So as to payments made to an independent contractor, they have a special form now called a 1099 NEC, which is different from the rest of the information that can go on a 1099 miscellaneous form. So folks out there who may not be aware of that, that's kind of a new development.
And you had a few webinars explaining
it. So I'm out on the circuit, if you will, on webinars on behalf of Lorman Education Services. We are out talking about the 1099, and one of the things we talk about there are the best practices that get into what folks should be doing when working with vendors and independent contractors in getting the proper information up front. A W-9 is part of that. But the best practices, how you can kind of avoid the problems of getting it wrong on the 1099 side.
So what should a worker or an employer do before submitting the SS-8?
Well, this is kind of at the end of the day, we want our listeners to know that before submitting an SS-8, get with your legal advisor to know the ramifications of what you're doing. Yes, the accountants can help in a huge way, but they're not necessarily geared towards the laws of that are beyond just tax laws. The danger I see in this is that you're kind of filling out this form with the IRS, but it has fallout impacting labor law issues, affecting rights of protection under the law, overtime laws, discrimination laws. Folks may not realize it, but you can be an employee under one law and not under another law. And that's because some of the laws are guided by what we call the common law, which may sound kind of nebulous, but it's basically a non-statutory driven approach, meaning case law and so forth, whereas some of the laws are remedial and they're trying to achieve a certain thing, and they'll actually put into the law a presumption of employment. And many states, when they look at these issues, Gilbert, they might have something called like an ABC test that says, look, I know we can look at 20 factors or 50 factors or 13 factors. We're going to narrow down to 3 primary factors. We're going to try and simplify the process. But in the process of simplification, they may say, but we're going to presume employment and make you prove otherwise. So the SS-8 is just an important document. And one of the last things I'll say on this, Gilbert, as we're looking at it, is the SS-8 in particular has various parts to it. Parts 1 and 2 and 3 and 4 and 5. And what I want the folks to know about this form is that when filling it out, they want all the documents submitted. So if there's things that are proprietary in a setting, that's where a lawyer can come in and talk about. There's also the idea that the IRS wants to look at everything to make a good determination. So there's a lot of questions here asking like, how long have you worked there? Why are you filing this form? Describe the firm's business. Why do you believe that, let's say, if you're filling out this form as a worker, why you're an employee or independent contractor? What's your title? Do you work under a written agreement? If so, attach that agreement. And then they get into these factors. And many folks have probably heard, many of the accountants out there will have heard of the 20-factor test. But it's not really the test that they're using here. They're using a categories of evidence approach that is broken into 3 parts. And if you know the magic of 3, you know what the magic of 3 is, don't you, Gilbert?
No. What's the magic of 3?
The magic of 3 is that you and I are playing a game, and I have to get 2 of 3 to beat you. Yes?
Yeah.
All right.
That 3.
That 3. So if I got to get 2 out of 3 to win, right? One attitude of any test that's built on 3 might be that 2 are easier to prove than 3. Now that's a kind of particular view, but under the common law, one of the things that the 20-factor test did not do that the IRS had many years ago was, there were court cases that discussed how it needed to consider the parties' intentions. And as you know, if the parties intend to set up an independent contractor relationship and they put it in writing, and their treatment of that is consistent with that, a test like the 20-factor test not factoring that in was not a proper test, and the courts held that way. So the IRS kind of adjusted, and they've picked up that category under Part 4, where they look at the things. And it's much more broader than just the intention. So to be fair to the IRS and how they look at these issues, they look at what that relationship would look like. So if you look at just that part, it says, are you getting benefits? Can the relationship be terminated by either party? What else? Is there a non-compete? Is the worker a member of a union? Is there any advertising going on? How is the firm representing the worker to customers? And under whose business name does the worker perform the services? So that kind of thing. So all these things, when you get into them, it's a pretty involved form. And if anyone has an SS-8 issue, Gilbert, we'll want them to come to somebody like me to kind of make sure they get good legal advice. Because what at first may be the thing to do, maybe upon reflection with good advice, you decide not to do it. Or if you do it, you get that input to do it right, to make it look professional, make it look right. And so these are the kinds of things that we just want to get the word out. And the accountants out there, if they get a client that comes to them and says, I want to do an SS-8, we want them to be careful, because many times accountants are bridging the role of working with a business and some of the workers. And so that's a conflict, right? Because, how they're doing things.
Of course.
So, again, anything we can do when an SS-8 issue comes up, come see us. Come see somebody like me. Go see somebody
See the
that has
expert.
the legal right. Go see an expert.
And not
that
try
was-
to fill that on your own.
Correct.
And deal with it on your own.
Yeah, because the words you use here could be used against you.
Oh, wow.
In some other context, right? So
course.
you wouldn't want that to come up, or at least have the possibility of coming up.
And then try to get out of a situation, fall into another situation.
Right.
So you heard him, folks. Come to the expert, T. Scott Tufts, right here. I call him the master of tax law. You can call him at 877-647-7887. Again, 877-647-7887. You can email him at any time at stufts@cplspa.com. That's stufts@cplspa.com. And if you have any questions, don't hesitate to call or email. Thank you for today, and we'll see you next time.